I'm perusing through the docket for the major record label lawsuit against Suno today and stumbled across something I'm not sure they want you guys to see, but here we are. In looking at what is a discovery dispute, Suno is making a pretty jaw-dropping accusation. Suno appears to be claiming that the major record labels engaged in conspiracy to put Suno out of business, and that in fact the lawsuit that is pending right now against Suno is part of that conspiracy. Now, as far as what we're talking about today, it's twofold. One, we're going to take a look at what Suno is saying because this is a pretty big deal. And it seems that Suno is using this as almost its anticipated defense to what otherwise is copyright infringement. Now there's this DMCA infringement of allegedly scraping all of the music or most of the music that the AI models trained on from YouTube. We're going to talk about that, but actually that's part two. So part one, what is this alleged co-conspirator thing that the major record labels, well, again, allegedly did, but then two, with this DMCA count that not only the major record labels have added in the lawsuit against Suno, but actually in our class action lawsuits on behalf of independent music creators, we have added this as well. And we now have Suno's position, and we're going to talk about what that is. So let's start with just I gotta tell you, man, I just paused when I saw this allegation about the conspiracy because, again, it's a big deal. So in a letter that was put together, not just Suno, but also in conjunction with the major labels, they put together this letter and gave it to the court. And so this is, again, in regards to a discovery dispute. So let's take a look and see what's going on. All right, filed with the Honorable Paul Levinson. So this is Suno's position. As explained in the discovery dispute statement, in Suno's answer, it alleges two forms of anti-competitive activity in support of its copyright misuse defense, both of which are aimed at the same bottom line, preventing generative AI companies from gaining traction in the marketplace. Now, Suno is going to go on to basically explain in two parts. One, it's saying that the major labels orchestrated a concerted refusal to license their music to AI companies like Suno. And so they did this likely because they're all part of the organization, the Recording Industry Association of America. So that's part one. Part two is that the individual major record labels attempted to leverage what they're saying, their arsenal of, well, sound recordings, right? Their music catalogs. They go their giant music catalogs to pressure licensees not to work with Suno. So Suno is basically saying, well, this has been the plan all along. Allegedly, the major record labels used the fact that they weren't going to ever license. They weren't ever going to work with Suno or allow Suno to do this the right way. Here we all are saying, you know what, Suno, you should have done this the right way from the beginning. You should have obtained licenses. You should have purchased copies of the music. To the extent today, you are now saying this is fair use and we should not be held liable for copyright infringement. So that's the allegation, but I think it's kind of looking like they're saying, well, we tried. We tried. The major record labels, they're not going to play ball. And then the major record labels turned around and sued, well, Suno. Going on to say, Suno now seeks to compel discovery from the major record labels. Suno has alleged, upon information belief, that the major record labels engaged in a concerted refusal to license their songs to AI companies like Suno, and they orchestrated through the organization RIAA. The basis for Suno's allegation is both Suno's understanding of discussions in the industry and the application of basic economic principles to the facts. Under competitive conditions, record labels would be vie against each other to monetize new technologies going forward. As I'm reading this, I'm like, well, I do know that Universal, for example, from the outset of all things AI, announced right away, we're working on our own AI, not only technology, but collaborations, right? So we're working on these collaborations. We're all about the AI, but we're trying to do this ethically. We're trying to get our artists to opt in. If they're saying that this was kind of anti-competitive behavior, Suno goes on to say, well, if this in fact is the case, and we believe it is the case, and actually that's why we're here today, court, because we are trying to get all these extra communications, all these emails, all these messages internally, where the major record labels exposed the fact that they intended to never give us licenses. Okay, interesting. So they, as you'll notice, from what was filed with the court, they have redacted, they have blacked out sensitive information. I'm assuming this is stuff about, who they reached out to, company names, allegedly, how Suno does things. So in correspondences, the major record labels have attempted to avoid the clear implication of this alleged course of conduct by arguing that Suno did not attempt to license its songs before them as training data and by gesturing towards settlement conversations that have occurred since. Hold on to that have occurred since the major record labels filed suits. Do you guys remember a few months ago, we were reading, and it was reported, right? Nothing official, but it was reported that there were settlement talks amongst the Suno and Udio and the major record labels. Are they going to settle and be done with their cases? Well, we haven't heard anything as far as settlement, but this sounds like, in fact, there have been settlement communications. So, again, Suno seems to be saying this is all bad faith. You set us up. You were never going to license and all that. And now you're leveraging your lawsuits, you're leveraging your relationships, right? Because we do know that the major record labels are very plugged in with music streaming platforms, for example, Spotify. So let's see. These arguments have no bearing on Suno's copyright misuse defense. There was a period before this suit was filed in which the three record companies, who are the plaintiffs here, plainly coordinated between and among each other jointly to cut off ongoing conversations with Suno that were intended to yield forward-looking license agreements with respect to future conduct. This is copyright misuse at issue. Suno requests discovery from plaintiffs related to the concerted refusal to deal with Suno and other generative AI companies. Now, when I initially read that, I'm like, oh boy, well, to me, what I do know in discovery disputes, I go, well, if you're saying that there are emails where you reached out to Universal and Universal said, we don't want to deal with you, right? Or just ignored you. Well, you have those emails, Suno. Or is it that what you're looking at here is you're looking for any communications internally between Bob and John over at Universal being like, hey, screw these AI companies. We're never going to deal with them. Is that what you're looking for? Plaintiffs refused to produce internal documents and communication concerning their willingness to license their works to generative AI companies. In other words, plaintiffs' proposal deliberately excludes the very documents that are essentially relevant to this inquiry. So they're, Suno's basically saying, court, major record labels, they've produced some stuff. They haven't produced all the things that we want that go to this theory. The major record labels responded. This is what they had to say. The present dispute is the second time in 2 months Suno has come to the court seeking expansive discovery to support its legally infirm copyright misuse defense. This time, Suno is seeking expansive discovery in pursuit of its theory that plaintiffs have engaged in a collective boycott of generative AI companies, likely orchestrated through the RIAA. Suno premises this theory on its understanding of unspecified discussions in the industry and the application of basic economic principles of the fact. But these vague, unfounded allegations come nowhere close to justifying Suno's intrusive and highly burdensome demand of all documents and communications, including purely internal documentation. To limit the scope of Suno's clearly overbroad request, plaintiffs have agreed. And so this is what the major labels said they would produce, right? So studies, surveys, communications with third parties, governing the licensing efforts, documents, communications. Okay. So, the major label position is we have actually provided everything. They're on this fishing expedition. Those are the words actually used in the letter to say this is Hail Mary attempt to come up with this big legal theory, which, to be honest, is it in response to that Barrett's author settlement that we just covered, right? So it's in the billions of dollars to settle a class action lawsuit where the court had just found that pirating copies of copyrighted things, not fair use. So I'm wondering if that is how Suno is kind of positioning this. But anyway, that's not where this ends by any means. This is just one battle that's kind of ongoing, but I'm curious what you guys think. So drop a comment below, which brings us then to the second half of this, which is the DMCA claim. Now, if you guys remember, the new DMCA claim against Suno and Udio, including in our class action lawsuits, is that it's not just copyright infringement now. There's a new instance of infringement. The Digital Millennium Copyright Act has this provision that says if someone or a company breaks through technological measures right, to gain access to copyrighted stuff. If you break through the lock, then this is going to be an unauthorized access. And if you do that, it's now an expansive way to actually get damages separate from the copyright infringement. And what's been interesting is that in what we have seen in the positions taken thus far from Suno is that Suno doesn't seem to be disputing it. What it says, instead of just this whole allegations of scraping on YouTube, in its response, it goes, you know what? Even if that's true, DMCA doesn't apply because you know what? We were just going in to copy, and you have to be able to do that in order to have the fair use of the stuff itself. The way that I kind of think through this, I go, okay, there are other cases that have dealt with this. And one in particular had to do with DVDs, right? So the court looked at, are you okay to go and rip the file from the DVD rather than just put it into the DVD player and press play? If there's anyone who's watching this right now who doesn't know what a DVD is, please drop a comment down below. We were talking about this. We're like 10 years away from people not knowing what a CD is or a DVD is. Hopefully we're not there yet. In that particular instance, the court determined that if you essentially rip the file from the DVD, that's not the way that it was supposed to be consumed. That's not the way that you are allowed to access the copy. So that is a breaking through to access. So in the same kind of way, if we're looking at YouTube, there's this thing called a rolling cipher. And in order to access the audio visual, so meaning the video file itself, the song file itself, can you just go to YouTube right now and get it yourself? Well, the answer in the argument is no. So in any case, the record labels fired back, and I thought I would just point this out. This is from their reply. So they go, while Suno may invoke fair use, right, though it will fail to justify copying the major record label's songs to train its AI model, fair use cannot excuse the initial access obtained by circumventing YouTube's TPMs, which is the technological protection measure. So if Suno wanted fair use to shield it from liability entirely, it could have acquired its training data lawfully. Instead, it chose a cheaper and faster route, stream ripping from YouTube. All right, so in kind of where we land as of today, the DMCA issue is being hotly litigated, and also outside of even our cases. It is something that is on appeal right now. And in fact, we covered in our last video, you should check that out, how Suno and Udio have teamed up to file what's called an amicus brief. So they have filed into that case to try to persuade the court about this DMCA thing of just like, you know what? It should be free reign. And this is how I interpret it. They're saying it should be free reign, not just on YouTube. If anyone's videos, music are posted anywhere online that you can go and press play right now, it's free reign for any AI company to come and get it, even if they're breaking through some kind of technological barrier. They should be able to go get it. They should be able to train their AI. No DMCA violation, no copyright violation. That's my understanding of what Suno, at least here, is claiming. Now, for those of you who want to get involved in our class action lawsuits, if you're a music creator, you can still join by going to topmusicattorney.com. Be sure to, at a minimum, just get on the email list because we're going to be doing a copyright drive. It's very important in order for you guys to get the damages that you are rightfully entitled to, that you have your copyright registrations. So I'm going to help you to do that. We are literally going to do a copyright drive. So get on that email list, topmusicattorney.com, and that's where you can sign up if you, in fact, want to be a plaintiff. I'm Top Music Attorney, and I'll see you on the next one.